fuck up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man. You're going to learn. Calls the case of the people versus Marquesi Hankey.
I'm letting them be happy, Your Honor.
Good afternoon, Your Honor. Attorney Kevin Masson, except one.
All right, it's your motion.
I did file a motion to state that previous PCC hearing, my client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contacted the complainant. Following that particular bond hearing, my client not contacted the complainant with period from the jail. Also instructed my client that if allowed to be back on bond, we would ask the court to hopefully reinstate his original bond with tether. I would note, Judge, that he has no prior criminal, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. Yes.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then.
And this is where the tension spikes. The judge isn't just skeptical, he's outright stunned. Think about it. Walking into court free on bond, having it revoked for violations, then still disregarding orders. That's almost like daring the legal system to punish you. Judges are human. They can forgive mistakes, but they can't ignore patterns of outright defiance. Right here, we're seeing the balance between second chances and protecting the integrity of the court system.
You know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world's stopping me from you. I don't give a fuck what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request of the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's very about myself. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. So, again, please show mercy. Please.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge
Perry.
Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both of victims' new numbers and old numbers, so there should not be any more.
More calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.
Today's courtroom moment is one that shows exactly what happens when someone pushes the justice system too far. This case involves Maurice Hankey, a defendant who was already given a chance by the court. He had been released on bond with strict conditions, including wearing a monitoring tether and following the judge's orders. But according to prosecutors, those rules didn't last long. Instead of complying, Hankey allegedly cut off his tether and started contacting the victim again. Not once, not twice. Prosecutors revealed that he made dozens of calls even after. His phone privileges were revoked. In court, the defense tried to argue that Hankey deserved another opportunity. His attorney pointed out that he had no prior felony convictions and asked the judge for leniency. They even suggested placing him back on bond under strict house arrest. But the prosecution had something powerful to present. Recorded jail calls. According to the court, Hankey used different PIN numbers and managed to make 45 calls to one number and more than 20 calls to another, all after the court had clearly ordered him not to make contact. In one of those calls, he reportedly said nothing in the world was going to stop him from talking. That statement changed the tone of the entire hearing. The judge made it clear that the court had already given him trust once, and that trust had been broken. While the defendant tried to apologize in court, the judge delivered a message that left the entire room silent. Mercy, the judge said, is earned, and in this case, the court decided that mercy had not been earned. The motion for bond was denied, and the defendant will remain in custody as the case moves forward. This hearing is a reminder that court orders are not suggestions. When someone repeatedly ignores them, the consequences can be serious.